Welcome to another edition of the Plan Well podcast, hosted by owner and attorney of Cary Estate Planning, Paul Yokobitis.
Hey everybody, Paul Yokobitis. This is the Plan Well podcast, season 2, episode 3. And today it's another solo episode. I wanted to hit on a topic that's incredibly relevant right now with the impending election coming soon. By the time you listen to this, it may have already happened, but we're recording this on October 27th. And right now, projections, look a certain way. So with that, there's always the question of, how does estate planning change in a Washington that looks very different? And so with the election looming, I wanted to sort of hit 5 or 6 points that may be prudent to your planning, whether you've planned yet or whether you've not begun planning as far as your estate planning is concerned, and how things may change in a Democratic Washington if that's what happens. Now, to be clear, a lot of dominoes have to fall the right way for any of this to be, incredibly relevant to planning decisions and changes. What that means is essentially Democrats would have to hold the House, take over the Senate, and take over the White House. And so you would have to have a unified Washington, 100% Democratic controlled in order to get any of this to pass. As we've seen over the last decade, when there's a mix of control, there's not much that gets done. So there's obviously some current legislation or rules or current law that is in place that has some known sunset provisions in the future. And that's going to be, the tax reform that was passed in 2017, made effective 2018, that effectively doubled the lifetime unified estate and gift tax exemption. So as we sit, should nothing change right now, the current exemption is $11.58 million per person. It does stack or double between spouses. There is what we call portability. So the surviving spouse can use the deceased spouse's unused exemption and stack it onto theirs. And if nothing changes, that's expected to increase to $11.7 million. So combined, we're well over $23 million for a married couple. We do know for sure, though, that at the end of 2025, that exemption will be cut in half. And that's because the tax reform included a sunset provision. So it was only going to make things good for a certain period of time. So what that means is we currently have very high exemptions that don't really, force that many families to plan for estate tax. So a lot of planning that's being done right now is not the type of planning that was being done in 2000 or in the early 2000s and earlier, which would be, credit shelter trusts, AB trusts, whatever you want to call them, which were more estate tax driven, trying to eliminate or minimize estate tax between spouses and after both spouses pass. If things change and, or rather, if nothing changes and the sunset actually happens, then we're back to where we were, between 2010 and 2017, which was roughly 6 million in exemption, still stackable between spouses. And so still most families don't need to worry about estate tax. There's certainly plenty of families that do, and certainly much more that will after 2025. But a Democratic controlled Washington makes that look a lot different potentially. And so while nothing is really firm, like there isn't any proposals, to do this, there is some rhetoric around tax changes that the Biden administration wants to enact. And, part of that was repealing a lot of what 2017 did. And, their stance is that it wasn't really fair for most people. So they want to undo it and provide more middle-class favorable tax cuts to reshape the way that reform worked. Probably means repealing a lot of it. And so what could first happen would be if there's just a repeal and not a repeal and replace, then we would likely just go back to what the permanent exemption is, adjusted for inflation, which would be about half where it is now, right? So we're about 6 million per person stacked for married couples. that would still put us in a world where most families don't need to plan with the state tax in mind, especially in North Carolina, because we don't have it at the state level. So we're just really looking at the federal exemption. But that may not be the only change that's made. Part of the Democratic platform was to reform revenue collection. So, increasing sources of taxes. And generally the types of things that we plan for as estate planners are the types of taxes that are usually incurred by or paid by wealthier families. And so Democratic policies generally don't favor wealthier families. They generally favor middle class and lower class families. So the types of things that may come up would be, obviously adjustment of the estate tax exemption to lower it. If you look back to 2016, when Hillary Clinton was the candidate, her proposed budget or proposed tax plan was to lower the exemption to $3.5 million. And again, still stackable. So 3.5 per person is 7 million per couple. So more people impacted, but still vastly, it's not the vast majority of Americans. But for a lot of people, that would be significant, especially if you have a lot of life insurance or if you have a lot of retirement assets. That could trigger a potential estate tax liability in the future. We also could look at an increase in estate tax rates. So the actual percentage of tax that's being paid if you do have, wealth in excess of, whatever the exemption is at that point. What that could mean for estate planning is that, anybody who's really done estate planning that was not estate tax driven will probably need to reevaluate their planning to see how adequate it is for their circumstances, the likelihood that they may have a taxable estate given wherever the new exemption falls, and then the structure of different tools that may be used. A lot of people didn't use trusts at all, or if they used trusts, they weren't what we would call credit shelter or bypass trusts. That were they were more worried about protecting assets for kids or avoiding probate or some non-tax purpose for the trust. And so now that estate tax is more viable for more families, it just warrants a review of what's in place. Some families will certainly need to modify what they have in place because of that. We would generally see then a return to a more common use of credit shelter and bypass trusts to eliminate estate tax between spouses and then limit or eliminate estate tax after both spouses pass. We could also have families who sort of fall in the in-between where they could take advantage of an elevated exemption now, making completed gifts from a tax standpoint to an irrevocable trust to utilize their larger gift exemption. And then, taking advantage of that before the exemption is lowered. And that would be using, specifically created irrevocable trusts. If the wealth is held predominantly by one spouse over the other, then we could use what are called spousal lifetime access trusts, which is essentially creating a credit shelter trust while you're alive for the benefit of your spouse. Now, obviously, if you and your spouse are on good terms, then it's all really the same. It's coming into the same household. But it can lock in some estate tax avoidance benefits. We may also see a change to the step-up rules when it comes to capital gains treatment and cost basis. So right now, the way cost basis works, and in terms of the step-up in cost basis, is that whenever you pass away, if you leave appreciated assets or even depreciated assets to a beneficiary, and that transition or transfer is triggered by your death, so it's an inheritance-based transfer, then your beneficiary would likely receive a step up in cost basis. So their cost basis, which is the number upon which capital gains tax is quantified or calculated, would be the fair market value of that asset on the date of your death. So one potential change that we've sort of seen in the news or seen reports of being a possibility would be a modification of how that works. That, some people believe that the step up itself would be taxed, but that the step up would still happen. So instead of having, a switch to a carryover basis, that there would be capital gains taxed against the asset at death for the gain that existed for the decedent, but that the beneficiary would still receive a step up in cost basis to, move that point for any future sale, so that it's not the basis of the decedent. And so that could warrant the use of, lifetime transfers into irrevocable trusts, more long-term trusts, to be able to hold until a more favorable tax climate is reached. And that's just as simple as, Congress changing their mind. Another change that could happen, obviously the most likely are tax-based changes, but the Secure Act is something that is new. It happened, or it passed at the end of last year, effective the beginning of this year. And it really changed the way that your beneficiaries receive your retirement assets by eliminating what was called the stretch, or the lifetime expectancy stretch, or life expectancy stretch, for beneficiaries, so that they could take required minimum distributions based on their own age over the rest of their life. The Secure Act capped that at 10 years and basically eliminated RMDs for your beneficiaries unless they were disabled or a spouse or less than 10 years younger than you. So one, I think, very easy change that could happen to more adjust things to a favorable climate for the middle class would be to undo some of the Secure Act changes. Most likely the generational stretch removal. So again, a change that could impact your planning, because a lot of what we've been doing over the last year is modifying trusts to be accumulation trusts instead of conduit trusts, which was a lot more appropriate last year and before. So we could have another pivot point on trust planning. Anybody who's got a trust, we're basically always looking at, how Congress is changing the implications of how your planning works. And this is a good example of how, things can change year to year. We just had the Secure Act this year. It's potential that, another change could come next year. We never know what Congress is going to do, and that's not something that we can control, but it's certainly something that you can keep an eye on. And certainly our clients are being, readily made available this information about how things may impact their planning. We also are meeting with our clients on a regular basis, either an annual review after they're signing or every 3 years after that. So these little changes are always being, they're always the potential for changes to your plan, but it's not something where you're sort of left in the dark. We're always making our clients aware of those changes. It's important to understand that even if Democrats regain control, it doesn't look like it's going to be, or that there's really a possibility of Democrats taking 60 seats in the Senate. And so the filibuster is still a very real thing in the Senate. So it's likely that the Democrats are not going to get everything that they want. They still have to have, approval through the House and the Senate. The Senate has the filibuster. If things are too one-sided or too, all about the Democratic wishes and no meeting in the middle, then a lot of this is not going to pass the Senate, at least as long as, the Republican senators have the wherewithal to participate in filibusters. So keep that in mind. It isn't all doom and gloom. And of course, I don't want to, jinx anything. This is not a foregone conclusion. The election hasn't happened. It's probably not going to be done even after, Tuesday the 3rd because of mail-in balloting and those sort of things. So pay attention. We'll obviously give updates along the way and see what planning implications there are. And obviously, if there's any budget changes or any tax changes that are on the horizon that are being proposed, we, of course, will make sure that all of our clients are aware of those ahead of time. Thanks so much for taking some time to listen to today's episode. Hope you enjoyed it. If you're interested in learning more about estate planning, visit our website at caryestateplanning.com. Again, this is Paul from Cary Estate Planning with the Plan Well podcast, Season 2, Episode 3.
That's it for this week's episode. Make sure you like, subscribe, and share. We'll see you all next time.